in jail 46 or 20.
We find this appeal to be devoid of merit and the appeal stands dismissed.
Daily list for hearing item 2.
Malad, Mr. Endeka is on his legs on the other foot, Malad. That's over timing, Malad.
This is that matter where the eyewitnesses' accounts were a little inconsistent
Yeah,
with each
there was
other.
discrepancy in the eyewitness.
And
Call up next matter.
Lodge.
Item 3. Okay. Item 2.
May please, Your Lordship. Item 2, madam.
Yes.
Regarding that matter, 313 statement, the admission,
Yes.
and also the discrepancies in the evidence of the PW's matter. May I just first point out the discrepancies, madam? The PW1 matter, the wife of the deceased, she says that there were 4 other people who had confined the deceased and the appellant had hacked him with a dowel. He says she is an eyewitness. She saw the thing. She raised the hue and cry, and then PW2 and 3 came to the spot. In the middle portion, my lord, accordingly, I use hue and cry, hearing the same. Page 9, my lord,
Yes.
in the middle portion.
Yes.
One sentence above, my lord. As a result of the assault, my husband fell down on the ground. When I went near my husband, I found him senseless. Accordingly, I raised hue and cry, and hearing the same, Sarala Telly and Boykonda Telly, PW2 and 3, came to the place of occurrence and saw the incident. In cross, though, she says that she did not see the incident. First sentence of the cross examination. I did not see the incident with my own eyes. Then again, she goes on to say that the appellant is her brother. Now, my lord, PW2, the mother says, page 11, my lord. I know the accused person. About 4 years back in the evening at about 2 p.m., the incident took place. At that time, I was in my house. On hearing hue and cry, I came out of my house and saw that accused Jogoi inflicting blows by means of a dowel. Now, if I go to the trace map, my lord, at page 63, her house is at a distance of 62, my lord. Her house is at a distance of 100 meters from the place of occurrence. No, meters. Because the translation says meters. It may be cubit. . could be cubits also. But the translation says 63 D indicates the house of Basudev Tele, which is situated at a distance of 100 meters towards the southeast.
100 cubits would be approximately how many meters?
Which manner that I have to find out, madam.
No.
Null is around 12 feet, 12 feet. Because there is a distance called null, my lord. I have checked the Hancock dictionary, my lord. It is around 12 feet. Null means a pole measuring around 12 feet. My cubits. These are cubits to come out.
1 cubit is 0.5 meter. 1 cubit is 0.5 meter.
Then it will be half. But here the translation at 63 says
50 meters.
D indicates the house of Basudev Tele, which is at a distance of 100 meters towards southeast. 100 meters, my lord, we'll have to take it as 100 meters from the place of occurrence. Because it does not say what is the reference point of 100 meters. Because if it is at a distance of 100 meters, from a distance of 100 meters to C, and the timeline, my lord, it does not match. Because PW1 says that I raised hue and cry, then they came. Because by the time PW1 reached, he was already lying senseless.
Mr. Deka,
My lord.
please address the court on this issue. Let us assume that PW1 is not reliable. Will it be a ground to discard the testimony of PW2 if her evidence is otherwise found to be?
Exactly. If
Consistent.
it is otherwise found to be, we'll have.
Yes. Say we find that PW2, who claims to be an eyewitness, her evidence is free from contradiction.
My lord.
It fits into the prosecution story and there is nothing to doubt her presence at the place of occurrence. But the version of PW1 is mutually inconsistent, inherent inconsistencies, which shows that she somehow made mistakes or either deliberate or for whatever reason. So even if the court finds PW1 is not reliable, will it by itself
No.
put a question mark on PW?
Maybe not. Provided, my lord, it is otherwise reliable. Because we have to read the evidence, my lord, as a whole.
Yes,
Because PW2, what does she say? Now let us read again, my lord.
yes.
First line we ignore, she is my daughter. I know the accused. About 4 years back, in an evening at about 2 p.m. the incident took place. At that time, I was in my house.
Yes.
On hearing hue and cry. So this will have to relate with PW1's testimony, madam. Because she says she raised hue and cry.
Mm.
On hearing hue and cry, I came out of my house and saw the accused Jogoi inflicting blows by means of a dao on my son-in-law. Now this again, my lord, I'll again go back to the trace map, my lord. If it is 100 meters,
Mm.
then it is difficult to identify a person from 100 meters as to who exactly is inflicting the blows.
No, but it is, the trace map makes it very clear that it's not 100 meters, it is 100 cubits.
If it is cubits, then it will be around 50 meters, as my learned friend has pointed out.
Mm.
So from 50 meters is almost 150 feet. To say exactly that she saw the appellant. Then, my lord, I also saw accused so-and-so, so-and-so, so-and-so kept the deceased confined. This is a contradiction, my lord. These people have been acquitted and the PW3 says it was Jogoi alone. Then I raised hue and cry, but none came to the place of occurrence instantly. But when the deceased fell down receiving the said dao blows, the neighboring people came to the place of occurrence. No one has been examined, my lord. My house is situated at a distance of 4/5 nolls away from the house of my daughter. This again is an inconsistency because 4 and 5 knoll is around 60 feet. As per the trace map, it will be much more than that. Because admittedly, the house of the deceased is at the top of a tilla. Here, although the distance between place C and D is not given, it appears to be much more than 50 feet. incident occurs at A. No, she says C, na? Not from the place of occurrence, from the house of my daughter.
So anyway, there are some inconsistencies.
There are some inconsistencies. Then again, my lord, in the PW3, he also says he was in his house on hearing hue and cry. I came out of the house. My house is situated at the place of so and so, distance of 2 knolls away from the place of occurrence. I saw that the accused was inflicting dog blows at the place. I have found accused so and so at the time of occurrence. He does not say that he saw the other accused persons confining them. He says that he saw them at the place of occurrence.
But everybody is consistent on one point, that it is the appellant who had inflicted the blows.
That is them. Although my lord, PW4, although he says that he saw his house, he is at his house is half a kilometer away, my lord. And he is, I think, the uncle of the informant. He says that I did not go to the place of occurrence out of fear at page 16. And yet he says that I saw in page 15, my lord, I saw accused Jogoi committed murder.
So we have a case where 3 witnesses, they claim that they had seen the appellant inflict the dog blows.
Yes. 4, my lord, 4 witnesses.
4 witnesses. So there are some inconsistencies. But they are firm on one point, that it is the appellant who had inflicted the dowry. And the appellant himself is also firm on that. That he is the one who had inflicted the dowry. We as judges have to now decide that all of them, including the assailant himself, was telling a lie.
No, my lord, so far as inflicting the dow blow, my lord, that may be the admission and the eyewitness, but the reason behind the last question in the 313, my lord, I am urging your lordship to look into that, my lord. I've got 2 judgments that when a 313 statement is considered, my lord, it has to be taken as a whole. You cannot accept the inculpatory part and exclude the exculpatory part, my lord. Although there is also a judgment that you can do that, but
Nishikanta Jha, you have
no, my lord, I am relying on the Dwarka Prasad, my lord.
Dwarka Prasad is there. Yes.
It's a
Is
1990.
Nishikanta Jha also one
Yes.
of those? 1969 SCP.
1969
But then Privy Council says it has to be read as a whole.
Before that, the view was different. Before that, it should be taken as a whole, cannot separate. But Nishikant Jha, this law changed.
My lord, in fact, in Dwarka Prasad, it says as a whole. 2010, it says as a whole. 2002, I have found that it can be.
But those
No,
are
you see,
164
those are not
confessions.
relevant here because those judgments are rendered in the context of confessional statement
Ah.
made under section 164 CRPC. This is certainly not confessional statement.
No. But here, this one deals with a 313 statement,
Please read.
my lord. So far as the present, paragraph 15, my lord. So far as the present case is concerned, the injuries found on the person of the appellant are not serious in nature and mainly on the ground that prosecution has suppressed those injuries. The appellant is not entitled to be acquitted. But those injuries can certainly be taken into consideration while judging whether the defense version of the accused is probable. The motive disclosed on behalf of the prosecution for the occurrence is not acceptable. Even if it is assumed that because of some altercation 10-12 days before the date of occurrence, the appellant had decided to cause the murder of Jagdish, then more injuries would have been caused on the person of the victim by the appellant instead of an injury of 1 inch by 1.5 inch. The prosecution case regarding assault of Ramesh with a knife on Chandrapal has been disbelieved by the trial court as well as the High Court. The delay in lodging the first information report by so-and-so has also not been explained. The occurrence according to the prosecution took place at 6 p.m. in the evening. The victim, while being taken to Debai, which is at a distance of 5 kilometers, expired on the way, my lord. This is on the facts, my lord. Then paragraph 16. The High Court has not disbelieved the version disclosed by the appellant. The High Court, on consideration of the evidence and the circumstances of the case, has observed it is true that this respondent gave a different time of the occurrence and this version and his version of the occurrence was also different. And it has been disbelieved by the learned session judge, obviously on cogent grounds. But this cannot wash out the effect of his clear stand all through that there was a marpit between him and the informant and the deceased in which he had wielded a spear on them. This part of this respondent's version was clearly severable from the rest of his version, and it was not at all necessary that if this learned session judge disbelieved his version regarding the manner of the occurrence, he was bound to rule out of consideration this admission of the respondent, which was certainly separate and severable from the rest of his story. The High Court has used the part of the statement of the appellant as an admission. According to us, that part of the statement made by the accused under section 313 of the code cannot be used as an admission supporting the prosecution case. It is well known that an admission has to be taken as a whole. It was not open to the High Court to reject one part so far as the aggression and assault by the prosecution party, which according to the appellant preceded giving of the Balaam blow, and to accept only the later part of the statement that gave a Balaam blow for the purpose of convicting the appellant. In the case of so-and-so versus so-and-so, it was said, it is quoted by lot, it is settled law that an admission made by a person, whether amounting to a confession or not, cannot be split up and part of it used against him. An admission must be used either as a whole or not at all. The High Court should have taken the whole statement made by the appellant as an admission and then should have examined what shall be the effect thereof on the prosecution case. According to us, taking all facts and circumstances into consideration, the version of the accused of the occurrence appears to be probable and acceptable. And in that 2010, Malo, there is one just in paragraph 87, there is a sentence. The law in this behalf is very clear. The examination of the accused cannot be dissected so as to rely on the inculpatory part and ignore the exculpatory part. The examination of the accused has to be read as a whole.
So
So if it is read as a whole, my lord,
what
then
is the 313 statement of the accused? Which part do you think?
last question, my lord. 15, question number 15. The deceased Dilip always used to assault me and my uncles under the influence of liquor. On the irrelevant day, he hired some persons from so-and-so and being armed with gun came to my house and attacked me and asked me as to why I filed a criminal case against him. Then I took out a dao from my house and inflicted blows on him. The remaining accused persons are not at all involved in the occurrence and they are not present there. They were not present there. They are innocent.
So for what purpose you are inviting
My lord,
our attention?
The right of private defense, my lord. That is what I can argue.
Right of private defense?
Because if he is attacked with a gun, a person comes to his house with a gun, he can very well,
No, but right of private defense, he has to prove,
my lord.
is it not?
But the learned session judge has ignored this evidence as not true. Learned session judge, my lord, has ignored this as not true, not believable.
No, but this is not evidence.
This is not evidence. This is not evidence.
Then
But while taking the admission that yes, I have killed him, this part has also to be considered, my lord. Why I killed him? Because it says he has been harassed regularly, and on that day he had come there to my place with goons, and I retaliated.
yes, and
Because other than that, my lord, there is no motive as to why I killed him.
you are not even arguing for conversion. Probably
Well,
there is no
conversion, because the blows, the manner in which he has been attacked, my lord. Had it been a single blow,
No, Mr. Deka, you please argue whatever you
My
think
lord.
is legitimately permissible. We will see what can be done, but you are free to argue your case. Don't feel inhibited. However difficult the facts might look.
the facts are difficult in a sense, my lord. Had it not been for the 313, my lord. I respectfully submit, my lord, prosecution has failed to prove the case beyond all reasonable doubt. Because there are inconsistencies in the evidence.
So that's what does the law say? What happens when there is evidence to prima facie indicate? And the accused in his 313 statement also admits, then what is the impact?
The admission has to be read along with the prosecution witness, my lord.
Correct. So what will be the impact of that?
Difficulty what I am finding, my lord, is in the cross examination also. Two witnesses have said that we have seen it. And
Two witnesses,
two witnesses have said,
they've remained firm.
they have remained firm. But I have to be fair to your lordships, my lord.
That's right, we've seen it.
In the
That's
cross also, two witnesses have remained firm that we have seen, although in my respectful submission, there was no need to ask him that question. Whether he had seen or not, my lord. Because in the witnesses, in the chief, he has said already.
So many things unnecessarily happens.
My lord.
What to do?
Because if I remember, my lord, in one amicus curiae, there was a case of dacoity, my lord, where the PW1 said that I have not seen him. Did not see them, any one of them. It was dead at dead of the night. But in the cross, it says that I could identify them from the voices.
So
So what was
probably-
the need of asking that question, my lord?
Correct. That's right. We can talk about it
My
some
lord.
other time.
My lord.
But for now, what else do you have to argue? So you agree that if the admission of the accused in 313 is found to be in sync and consistent with the prosecution story, then it has to be accepted, not only accepted, acted upon by the judge.
Yes,
That you agree.
that I have found, that
That is the law.
is the law.
And let
But
us see.
when again, this is also the law, madam, when you are considering, we are considering the 313. While we are, the learned court below has accepted that he has killed him.
Hmm.
Why he has killed him, whether it was grave and sudden provocation, that has not been considered, that has not been answered.
No, but where is the material to raise that point?
Except this statement, madam.
But in that statement, he doesn't give any description of anything. It's
He
just
does
a
not
bald-
give any description, my lord. And
bald
difficulty is that there should have been a line of cross-examination. His suggestions put.
All right.
And the lordship will also come because it, under the exception one, my lord, when culpable homicide is not murder, my lord. The
mhm.
first exception, my lord.
Yes.
Culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident.
Mhm.
The above exception is subject to the following provisos. First, that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. That the provocation is not given by anything done in obedience to the law, is not applicable, my lord, or by a public servant. That the provocation is not given by anything done in the lawful exercise of the right of private defense. That the provocation was grave and sudden enough to prevent the offense that from amounting to murder is a question of fact. So, my lord, I'll respectfully argue, my lord, that if the entire 313 is taken into consideration, the lordship will kindly consider that whether it was a case of sudden grave and sudden provocation, and he had only exercised his right of private defense, my lord. 96.
That's right. But you see, this statement of the accused against answer question number 15
My lord.
also contradicts itself inherently, because he says it is the deceased who had come to my house with the hired persons with gun,
Hmm.
but those persons are innocent.
No, my lord, he is saying about the other accused persons
Correct.
who had been implicated by them, the PW 1, 2, and as well as the FIR, that they had confined him. These are not the goons, my lord, these are the local people.
That's what we are asking. A man comes with other persons armed with gun. Who is armed with gun? That he is not saying.
That is not.
And then he says they are all innocent. And when they came, I inflicted dog blows on them.
Yes, but respectfully, my lord, he is, I think, talking about the other accused persons. These are the accused persons,
Correct. But these accused persons, according to the appellant have accompanied the deceased.
He does not say so, my lord. He does not say these are the same persons, my lord.
He said he hired some person.
Yes.
Then
Hired some persons. Who are those persons? Because this is some persons from Lalashare, some other place.
all
And
right.
these are, I think, these people are, my lord, residents of the same area, my lord, because had they been from outsiders, my lord, they would not have been named by the PW 1 and 2. Because PW 1 and 2 have specifically named these persons. I have seen A, B, C, D confined them, my lord. So respectfully, my lord, I think he's talking about the other accused persons who were implicated, not the hired ones.
All right.
My lord.
Anything else?
Bombay High Court is supported by Nayana.
Anything else, Mr. Decker? Yes.
While looking at the decisions, I went through a decision on popular evidence, how it has to be read, how it has to be gauged. Now, in that case, I found that if there are two or more eyewitnesses and they give somewhat an inconsistent account of the offense, but the court should not go deeply into that. This is ruled out. I mean, if his evidence is not shaken in the cross-examination, a little discrepancies here and there amongst them should be ignored. The court should not go into very deeply into that. So here is a case where the eyewitnesses have differed to a certain extent. If we consider PW1 had not seen, she said, I did not see the occurrence, and probable enough because she stayed in a tila. She was there when her husband was called by the accused. She came down and then she came to the place of occurrence. So it can be a case while coming down, she did not see the occurrence.
She
But-
must have heard later and then deposed before the court.
She heard later.
But if you put aside PW one,
Hmm.
then what is the inconsistency?
2, 3, and 4.
Hmm.
2 said 2 is the mother, although PW1 said mother came later. But mother's house is exactly in the front of the accused house by seeing the sketch map. And the attack was in the middle of both the houses, on the road, in front of the accused house, outside the courtyard. So she has the capacity to see it. She heard hue and cry, she came out and she saw. Maybe she reached later to the place of occurrence. By that time, the daughter-in-law had come down and the daughter-in-law said she reached later. That can be a probability. She saw from her house 50 kilometers or 100 meters. And then she saw it and she was coming towards the place of occurrence. By that time, daughter reached. And so daughter said, mother reached little late. But not only that, there are other contradictions. Mother, father, this PW 2 and 3 said there were other persons. 4 said there were none. And 4 said, 4 I think is the father. Now,
4 is some uncle.
But 4 didn't go to that place. She saw from a distance.
Now 2 saw from a distance, but then she is not very clear in saying that before reaching the place I saw. That she did not say. We are just presuming that.
That goes
And-
other ways.
And then she went and then she saw her daughter crying there. But in the cross, that part is not demolished. It's there. PW1's cross is gone. There is contradiction. She did not say it to the police. But PW 2, 3, 4 crosses are intact. They had seen. PW3, he is Boykuntha Telly, he is the
So
brother.
the long and short of the matter is, there are lessons to be imparted among the young lawyers regarding cross-examination.
Yes.
And we hope some busy criminal practitioners, senior advocates
Mm,
who have good idea about cross-examination
mm.
will take out some time someday and do some,
Yes, training them or.
maybe Mr. Anshuman Bora, we don't know.
Yes.
He has time someday. Yes, Mr. Bora. Lot of complaints about the manner in which cross-examination is done. Both sides, prosecution, defense, and they have a point. It seems there is no clarity. People don't know how to cross-examine. Prosecution finishes their case while cross-examining. Defense revives it while defense cross-examining. It's a ambience of fraternity, we understand. That way the constitutional spirit in preamble is observed at least in one respect. But it's not doing any good to the system. That's the problem. So many cases, prosecution works hard to finish their case. Defense lawyer during cross-examination gives them a long rope. So many cases.
In this case, cross is horribly done because PW2 Lotche will see the cross. There is a public path running towards north-south. I found a deceased on the road in the front of the house of the accused. That part is dead. He found the deceased lying on the road. And after that, he said, I had seen him assaulting. These two doesn't go together.
These are matters which have been plaguing the system for very long.
True.
The problem is, as judges, we cannot go and impart training on cross-examination to the young lawyers. That is the problem. We cannot do it. We cannot tell the IOs how to investigate. We cannot tell the prosecutors how to prosecute. Because at the end of the day, we have to come and sit here and give evidence on what has happened. So if judges go and impart training on these things, then it will be seen as mindset of a judge on a particular point, which will be ultimately this information will be used in many ways, which may not be conducive for the institutional cause. But it is indeed very worrying. It's indeed very worrying. If you have any suggestions to make, please don't hesitate.
The only way to, my lord, I think not only the public prosecutor, the lawyers, training is must. Because I have seen the new lawyers coming to the bar, and from the very first day they are taking up the cases, which is even I today will hesitate in the first day without going to the papers. 302 cases, POSCO cases, these are very
That's correct. And
lots of victims
what
are
happens
involved.
is, sorry to interrupt you, the time taken in criminal appeals, these appeals, 10 minutes and 20 minutes judgment. That is how it should be. But the entire problem is created because of this confusion, chaos in trial and investigation. Of course, the defense lawyer is entitled to urge this and seek acquittal. They are entitled to.
Yes.
The prosecution, in whatever manner, will go on saying that this is our case. So this is what somebody said, some Delhi High Court judge, honorable judge, that in these matters, it is the judge who is put to trial.
Put to the trial.
Yes.
That's true.
What do you do?
Otherwise,
Nobody seems to be waking up from slumbers. Nobody. What do you do? These are, most of the cases are plain and simple. What is that big legal interpretation you have in hearing a criminal appeal? In how many cases? You may have 1 or 2 cases far and few between. Otherwise, what is there in it? What is there in it?
Yeah.
But the basic things are not done correctly. Whether it is the IO, whether it is the prosecution, whether it is the defense counsel. If the defense counsel has missed out on something, the court's conscience picks because for a lawyer's, deficiency, the court should not be unkind to a accused. But at the same time, the same principle has to be applied for prosecution also. If you are technical with prosecution, you have to be technical with defense. If you are non-technical with prosecution, these are the finer issues where at the moment it doesn't appear anybody is interested. But it is taking us towards a very bad scenario. Of course, we appreciate everybody is doing his or her job to the best of their. What do you do as a defense lawyer? When the brief comes to you, you make a note of what are the deficiencies and try hard to convince the court for acquittal. From the perspective of a defense counsel, only target is to get an acquittal or a reduction of sentence. From the point of view of the prosecution is cover up as much of lapses as possible. But the judge has to do justice because it is the society's interest which is at stake. Anyway, we
That's-
request you all to think about these things and come forward with suggestions. If the High Court as an institution can do something, we'll try to come forward with cooperation. But a time has come when we should set these things right to the extent possible.
Abhilash.
Yes,
There can be an option like while doing trial, a person has to be experienced a few years, that can be again done,
perhaps.
can help certain extent.
You have a director of prosecution.
No, not
Section.
yet appointed. Final stage, it is.
It is
going
final,
to be
but
appointed.
unless the CRPC is amended, it can't come into place. What do you do? It is in the
Hmm.
parliament, hand of the parliament. There are problems at every stage. Please.
Right. So Lordship, what we see here is if we brush aside PW1, PW2, his statement that he had seen the incident is intact in his cross. Although there are certain parts, he said, when I reached the place of occurrence, the body was lying.
Hmm.
In that case, he could not have seen perhaps, but then from a distance he saw, it can be again conclusion.
Any judgment on what happens when the prosecution evidence is supported by the admission of the accused?
There is a judgment,
Can you pass
Supreme
it?
Court judgment, it lends credence to the prosecution case. This is what happens. This is Ashok Dev Barma, I've given the list. Ashok Dev Barma versus State of Tripura. Paragraph 24, perhaps they have taken out SCC. I'll just read out. She will see Ashok Dev Barma versus State of Tripura. No light. Perhaps paragraph 20, 23, Lordship will go down below. It starts with paragraph 21. It starts with the line, "Wear of the view." Wear of the view, did your Lordship get? Paragraph 21 in Manupatra. Wear of the view, did your Lordship?
Yes, 24, yes, read, please.
Huh.
Yeah.
We're of the view that under 313 statement, if the accused admits that from the evidence of various witnesses, 4 persons sustained severe bullet injuries by firing by the accused and his associates, then admission of guilt in 313 statement cannot be brushed aside. This court in state of Maharashtra versus Sukhdev, 92-3, held that since no oath is administered to the accused, the statement made by the accused under 313 CRPC will not be evidence stricto sensu, and the accused, of course, shall not render himself liable to punishment merely on the basis of the answers given while he was being examined under 313 of the
All right, we're
CRPC.
ready. Acha, any scope of any conversion here?
Because his defense doesn't fit into the prosecution case. He said the deceased came with other persons, with guns. And then he got angry and he hit him. No, why will the
Yes,
people
next
with
matter.
guns
Yes.
stand there? So it's somewhat not fitting into.
Next matter. Anything you want to say?
Item 3.
May I please, Lordship, he is on lag on.
Hmm?
Please pass over for time being, man. Apply.
Item 4.
May I please your lordship? Lordship, senior advocate is on legs. Kindly pass over the matter for the time being. Yeah.
Who is on legs?
DK. Mr. Dilip.
Item 5.
Item 4.
Which is the
Madam, item number 4, madam. Madam, there is appeal by the agency, madam, against grant of bail to the accused. You also will find in the impugned judgment, madam. He started a mini trial, madam. You also be kindly just whether this impugned order will stand order. Page 106, madam. Just 106, Annexure G, madam.
who is appearing for the respondent? Who is appearing for the respondent?
Madam, notice is served, however, madam, respondent has not appeared. By 1/10/21, service complete on respondent to receive one, therefore respondent 1 on 31.
All right, let us see the impugned.
Whether your
judgment.
lordship will
Yes,
take it up in the absence. Whether your lordship will take it up in his absence, madam, the notice is served, that is office note dated 1/10/21.
no counsel is entered. Whose name will be shown? There are two respondents.
Madam, one respondent, madam. Only one respondent. Your lordship will find.
Two respondents. Do you have the copy of your memo?
one,
with
madam.
you? How many respondents?
Page 3, respondent 1.
Who is the respondent number 2?
Two, my lord, he has filed a bail petition. He has been joined, my lord, he has filed a bail petition. We don't seek any relief against respondent 2, my lord.
What has happened to the notice sent by registered post?
Nicolai? Huh? Huh? No, I don't. Registered post to. Itu phone oil na. Itu state पर phone oil.
Yes, all right. You want to argue?
Madam, at page 106, Malad, your lordship. Page
Page
106.
106.
Annexure G.
Yes.
Both the council, for the parties present as a matter is fixed for hearing today, learned council depends so and so for the petitioner, the accused A13 submit that while incorporating the statement in the bail appeal, number so and so submits that the name of the present accused appears in charge sheet at para 16.27 supplementary charge sheet, wherein there is no evidence to show that the present accused is involved in the instant case. There is no direct or indirect evidence to implicate the accused for his involvement. Therefore, he deserves to be released on bond. The land, specifically so and so, something he has come out of it. Accused number 13 was injured by bullet injury during encounter with security forces, which was by his own admission confirmed by duly constituted medical board at New Delhi on 1/1/16. Prosecution document number so and so was carrier of large numbers of arms and ammunition and other material transported by him and other cadres at the behest of SS Brigadier so and handed over to NSCNK. Town Commander so and so already arrested and charged sheet in this case for carrying the subversive activity by the strike team on 26/3/15. A13, that is respondent here, along with other accused so and so supplementary charge sheet, shows that A13 has a prima facie evidence against him in conspiracy planning, assistance, taking part of the execution of the attack on personal Assam rifle, making him liable to be sentenced under section so and so. So, submission of synopsis of objection against grant of bail and reliance is based on so and so, which is on record to be perusal on by this court. Heard both a person counsel on the from the perusal of the supplementary charge, the present accused is charged under second so and so. So the conspiracy and giving assistance to the group which attack on 19 Assam Rifle personnel at IG Stadium, Kohima. However, there is no prima facie material or evidence to show the involvement of present accused in conspiring with the members of
Mr.
the.
Das, what has happened to the proceeding before the trial court? Is it proceeding?
Evidence is going on.
So therefore, they must be appearing before the court.
That is, I couldn't say because he belongs to the underground group. So whether he has consistently appeared or not, that is difficult. Because in the notice of the Yology, will find that the notice is received by his bailer, the person who has filed a bail petition, not by him.
No, but the accused has to appear before the court. During trial, his presence is not required. Then you tell us, because if you are asking for cancellation of bail, we would then consider serving notice upon the accused through the.
Exactly, but my submission is that, my lord, this one because but a second prior, you also will find that it is a mini trial that he has gone.
No, that is on the merit.
He has said that whether this can be proved or not, that is a separate. Now the question.
No, Mr. Das, mini trial, wrong order, right order first. If we hear the appeal, then we'll go into it.
Yeah.
What we are saying is, because it is a appeal where you are asking for cancellation of bail. Somebody said that notice was sent to his village, some relative has accepted, etc. We wanted to be doubly sure that, because this will have implications in other spheres also. If this accused after getting bail is showing utter disregard to the court process, we will also take note of that. Why can't you tell us whether he is appearing before the trial court?
That I have
You are conducting the trial.
that I have to take expression with Kohima, that I have to.
Then you tell us if he is appearing, when is the next date? We will ask the learned, this is going on before the session judge.
Oh, yeah, Dimapur session judge. And I quote.
We'll have notice served upon him to the session judge.
Madam,
If that doesn't work, then we'll take a strong view in the matter. Because these are, you see, Nagaland, difficult terrains, other issues are there.
Right.
So if we agree with your view, assuming that we agree, cancellation of bail means if the accused is not to be found anywhere, then what is the point in hearing this matter now?
But
What happens if he is not present, if he is not reporting, if he is not, his whereabouts are not known? That means he is practically absconded. Then there will be a larger question. Why should we go into the question of the bail?
that is also one aspect of the matter, my lord. Because we say that
Why don't you tell us little later whether he is appearing and when is the next date fixed? Maybe we can have notice served on him and then post the matter. So that if he doesn't appear, we will have a concrete basis. But now some relative accepting notice in his village, etc. These are
that
in Bombay, in Calcutta, in Guwahati, you may accept it in one way. In those places, the relative might not have even informed him. Relative might just throw it somewhere. They live in their own world. Villages, in this rural setup, people live in their own world. Can you not do it? Say about 1 o'clock. Try. Then we can pass an order today itself.
let me see, let me try.
Or otherwise the matter has to be adjourned.
Let me try, my lord. If I can.
We're not convinced this process of service of notice has worked out, particularly since it is a remote location in Nagaland. It is not even in Kohima or Dimapur. And we also would like to know whether he is appearing, whether he is facing trial.
Facing counter. Then,
Should we post it next week?
no, কি করে?
Monday next?
Next week.
Can you show us the order, give us the order of the trial court, last order passed?
All right.
Give a copy of the last order passed. Last 1 or 2 orders passed. Let's see what is happening there. Let us see what is happening before the trial court.
I understand, ma'am.
Yes.
I understand.
On the request of Mr. D.K. Das, Senior Counsel.
Step by
BP Hussain Lordship.
BB
Hussain.
Counsel for the appellate. This matter is directed to be posted again on 19/12/2022 so as to enable him to obtain necessary instructions as to whether the respondent number 1 accused is regularly appearing before the learned trial court. And also to produce a copy of the last 3 orders passed by the learned trial court. Regularly appearing and facing trial before the learned trial court.
Series.
Item 5.
What a series.
May I please see, my lord? In the morning, my lord, I was supposed to not to come to court before this honorable court, as I am feeling unwell. But my lord, on last 2-3 occasions, adjournment was taken, and in between that, my lord, I am appearing as a legal aid counsel, my lord. Assistant jailer of Guwahati
But
Central.
you are appearing in legal aid counsel, you are, as a lawyer, you are appearing.
Yes, my lord.
Why are you not wearing the band? Is there any reason?
Because, my lord, as I said, my lord, I am feeling unwell, so someone managed to come due to some mild fever. I am extremely sorry, my lord. Extremely sorry.
You can't appear in the court.
I'm extremely sorry, my lord. I'm extremely sorry. But as I'm feeling unwell, that much, my lord.
What is to be done?
So,
We can send you to doctor, some medical advice.
no, my lord, since my lord,
Which case? Which case?
item 5, my lord. So, my lord, kindly permit me to come back, my lord, wearing this pen, my lord. I'm extremely sorry. Maybe
Lordship,
taken,
since he's feeling unwell, let the matter be taken up, your lordship, on some
But
other
these are all
day. He
connected.
doesn't have, no, item number
is not
5,
connected.
single.
From
He
6
doesn't have a
onwards.
very good case because there's eyewitness. He killed his mother, accused person.
On the prayer of learned counsel for the appeal, this matter stands adjourned and shall now be listed for hearing in the second week of January 2023.
my lord, I'm sorry, my lord. I am, my lord. That may be considered on that date, my lord.
Nothing more. You
Fine,
first
fine.
come
My
properly
lord, I'm
dressed.
sorry, I'm sorry,
We don't appreciate this kind of.
I'm
conduct.
sorry.
Item 6. 12.
Yeah, right. All appeals.
Yes.
What are these cases? 6 to 12?
Battery of lawyers are there, my lord.
You are appearing, Mr. Boda. What
Yes,
is-
my lord, I am appearing in item number serially 10, my lord, for the 3 accused appellant.
These are all connected.
These are all connected from 6 to 12, my lord.
It'll take some time, is it?
For me, it will not take some time.
No, but there are others.
For others, yes, my lord,
Where-
maybe, my lord,
Huh?
maybe, my lord. But regarding mine, I don't have much case here, to be frankly speaking. Therefore, eyewitnesses all are corroborated each other. There's no cross-examination virtually. And there is no point
Do you see chance of acquittal in these
No.
cases?
regarding my clients, I don't see any chances of acquittal. They are corroborated by 4 accused. Their name has been constantly taken by all the 4 witnesses, eyewitnesses. 164 also recorded immediately. It's also corroborates the evidence. And there is virtually no,
Then we were thinking, why don't we do it in the new year? Because
yes, ma'am.
many cases have been heard. We'd like to deliver judgment, particularly where
Yes, I am.
chances of acquittal are there. Chances, not guaranteed. Yes, you are also there, Mr. Why don't we do it in the new year? Okay with you?
No problem. I am also for 3.
Chances of acquittal?
One.
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 Huh?
For one of the accused, there is chance of acquittal.
But if we hear, we have to hear the whole.
Yes, my lord.
Yes,
Yes.
yes.
Because
Even if we hear it now, delivering judgment before vacation will not be possible.
Yes.
There are 8 or 10 matters already heard, judgment waiting. We'd like to clear all of them before vacation.
second day of January.
Huh?
January maybe, my lord.
After Bihu. After Bihu,
Yes.
all right. The learned counsel appearing for the appellants led by Mr. A. Bora, learned senior counsel, has fairly submitted that these matters would require detailed hearing, which will take some time, and therefore these appeals be taken up after the winter vacation. First up, Ms. B. Mia, learned senior counsel in APPSM appearing for the state, has also sought posting of these matters after the BU vacation. In view of the above, the registry is directed to list these appeals
My lord, first week of February.
as fixed items on first week of February,
Yes, my lord.
on 2nd of February,
Oh.
on 2nd of February.
Lordship is seeking in direction from this honorable court. Lordship, paper book is not available with us. Can the registry be directed to serve a
So
copy?
then add one line, Ms. B. Submits that he has not received paper book and therefore is not in a position to conduct the hearing of these appeals today. First up. The learned APP seeks posting of these matters after the upcoming Bihu holidays. Taking note of the submission of learned counsel for both the The registry is directed to list this matters for hearing as fixed items on 2nd of February 2023. In the meanwhile, copy of the paper book is furnished to the learned APP. Second February.
2nd February.
Pending matter, I will speak.
Ready to ascend other than that. May I please, your lordship, my senior is on legs, lordship. Otherwise, we are ready, lordship.
As prayed, no, but then we'll adjourn it. We have heard, there are some parted matters in the part two.
Yes, but Vijita, she's in court number 2. One pattern matter was there, your lordship.
Lordship,
Last
take
thing
after-
together.
After part third, lordship.
No, but she is in, she'll be doing, she's for the appellant. Miss Vijita, I saw her in court number 2.
See, we cannot start new matters now. There are already some matters we have heard and
Lordship.
we'd like to deliver the judgments. Because these appeals, writing a judgment also takes,
Lordship. Then lordship may fix any date, lordship.
on the prayer of learned counsel for the appellant, let this appeal be listed again on 3rd or you want to, 10th January,
Lordship.
2023, for hearing.
Part 2, 1, 3, 4 and 5, 7, 10, 11, 18, 19, 20, 21, 22, 23, 24, 25.
We will not take up the new matters. First, we'll finish off the parted matters. Then we'll sit at 12.
I'll inform her.
Yes. And the parted matters, if the councils are not ready, then we'll sit again at 2. But otherwise, we'll not treat it as parted because you can't keep accumulating parted. Yes.
May it please your lordship. Lordship, this is no direct evidence, no eyewitness, lordship, on the other circumstantial evidence. On that date, lordship, I have started with the evidence of 2 of the witnesses, lordship, that last seen together. The accused person, one of the accused persons had asked take the deceased along with him in the previous evening, 7-8 hours. Next morning, his dead body was found on the road, lordship. And so far in the Azahar, lordship, name of 2 accused person was there, one Ajizul Islam and one Dil Islam. Out of them, Dil Islam was acquitted. The another accused here, lordship, is Nazrul Islam. He was not a name accused. Against him, we found only in the evidence of PW 11, 12, 11 and 12. Only that they are the who had said about the regarding some bike, lordship, only that much evidence against this Nazrul Islam, lordship. So may I start from the Azhar or what? Lordship. Page 4, lordship. Azhar, I have the honor to state that around 8 p.m. on 1/5/2014, accused number 1 Muhammad Azizul Islam called my younger brother Faizul Islam away on a motorcycle from our house at Amtola, which is under Sadar police station. Accused number 1 took along accused number 2 and making my younger brother sit in between them. They went to the direction of Juria and thereafter they killed him ruthlessly by stabbing him and slitting his neck with sharp weapon at Telia Bebezia Patel. Be it mentioned herein that when accused number 1 called my younger brother away, my younger brother's wife Umme Habiba Khatun and my elder brother Muhammad Mustafa Kamal witnessed it. The below named person witnessed the accused number 1 and 2 taking my younger brother away. I therefore pray to you to take necessary steps against the 2 accused persons. The accused persons' name are Azizul Islam and Dil Islam, lordship. PW1 is the brother of the deceased, lordship. I am the informant of this case. I know the accused person. Deceased Faizul Islam was my younger brother. It has been about 5-6 months since the incident took place. On that day of the incident, I was not at home, but was at the market. Around 7 a.m. the following day, Sahabuddin of Dhingate informed me over phone that the dead body of a person resembling my younger brother Faizul Islam was lying by the side of the road at Juria and asked me to go there to see it. Then I went to my elder brother, who resides in our old house situated nearby my house. The old house is about 200 away from that of mine. On reaching that house, I asked my elder brother whether my younger brother was at home or not. Whereupon he replied that Azizul had come to the old house around 8 p.m. on the previous day and had taken my younger brother along from that house. At the time of the incident, my mother Jahura Khatun, my sister-in-law Ume Habiba, and elder brother were at home. Faizul did not return home after he had left the house that night. Thereafter, telling my elder brother about what I had been informed over phone, I proceeded towards Juria Road. On arrival at the place of occurrence, I saw my younger brother Faizul lying by the side of the road with his neck half cut. I also noticed simple injury mark on his back. My younger brother Faizul had already died. I saw him lying on the right side of the road while I was going toward Juria. Khairul Islam, Alaluddin, Ali Islam, and police personnel were present at the place of occurrence when my elder brother and I arrived at the place of occurrence. Police had reached the place of occurrence before our arrival. There, one Alaluddin told us that Azizul and Dil Islam had taken my younger brother towards Juria on a motorcycle by making him sit between them. Khairul Islam, Sahidul Islam, and Ali Islam made my younger brother seated on the motorcycle. Azizul and Dil Islam had taken my younger brother towards Juria on a motorcycle by making him sit in between them. The dead body was taken away for post-mortem examination. I lodged an Azahar that very day. That is on 2/4/5/14, the day on which I saw the dead body. My elder brother, sister-in-law, and mother were present there when Faizul was taken away. First, it is true that I stated before police that in the morning, Sahabuddin of Dhingate informed me over phone that the dead body of person resembling my younger brother Faizul Islam was lying by the side of the road at Juria. Going to our old house situated near that of mine, when I told my elder brother Mustafa what I had been informed over phone, he told me that Azizul Islam had come to his house riding a bike around 8 p.m. on the previous day of the incident, and taking my younger brother Faizul along, he had left the house. It is true that I did not state before police that going to the house on the day of incident, I asked elder brother Mustafa Kamal whether my younger brother was at home or not. Whereupon my elder brother Mustafa told me that Azizul had come to his house on a bike on the previous night and left the house taking my younger brother Faizul along, and that at that time my mother, elder brother, and sister-in-law Ume Habiba were at home. It is true that I did not mention in my statement that Sahidul, Khairul, Ali Islam, and Alaluddin said that Azizul and Dil Islam, making younger brother Faizul sit on a motorcycle, had taken him towards Juria. It is not a fact that while giving statement before police, I did not state that I had found my younger brother Faizul lying dead, that I had found his neck half cut, and that I had also seen injury on his back. Mustafa Kamal and I together went to the place of occurrence. The Azahar lodged by me was written by another person. I have forgotten the name of the person who wrote that Azahar. It is not mentioned in the Azahar as to from whom I had learned about the incident. It is not a fact that I have raised a false allegation against the accused. It is not a fact that the accused person did not commit the incident and that I lodged a case against them on false ground. I reached the place of occurrence between 7:30 and 8. I do not remember whether I lodged the Azahar that very day or the following day. Later says I lodged the Azahar on the very night of the incident. I have mentioned neither in the Azahar nor in my statement why the lodging of the Azahar got delayed for 11-12 hours. Police took my statement in my house 2 days after the incident. I found the police at the place of occurrence, but I did not ask them how much time before my arrival at the place of occurrence they had reached there. After having a discussion with my family member, I got the Azahar written and lodged it thereafter. I have not mentioned in the Azahar as to what type of motorcycle it was and what its registration number was. Azizul Haq is the registered owner of that motorcycle. I do not know anybody by the name of Jitu Ali. I do not know from whom the police seized the bike. It is not a fact that I do not know who killed my younger brother and that I lodged a case against the accused person on false ground. It is true that I did not state to police that my younger brother Faizul had been stabbed to death by the side of Nakabandha Juria Road. I also stated that he had rupees 35,000 and a mobile handset with him. It is not a fact that even though some dacoit had killed my younger brother and taken away rupees 35,000 and the mobile handset from him, I lost the case against the accused person on false ground. PW3, Mustafa Kamal. The informant is my younger brother. I know the accused person. Some of the accused person live near my house while some others live at a distance from my house. This is Faizul Islam was my younger brother. It has been about 5 months since the incident took place. The incident took place on the first day of May 2014. On the day of the incident, I was at home. Faizul's wife, Ume Habiba, and my mother, Jahura Khatun, were also at home along with me. Around 8 p.m. that night, Azizul came to our house on a motorcycle and was calling Faizul. Thereafter, Faizul went out of the house. When I asked Azizul as to where they were going, he replied that they were going towards Phakotgaon Bazar. Faizul did not return home that night. On the following morning, some people informed me over phone that Faizul Islam was lying dead by the side of Juria Road. Then I went to the house of my brother Mansoor and informed him that my younger brother Faizul had been killed. Then as Mansoor and I were going to the place of occurrence, police were carrying the dead body on a vehicle. They stopped the vehicle at Amtola and showed us the dead body. I saw Faizul's dead body with a slit on the neck. Cross. I did not witness who killed Faizul and how. My house and that of Faizul are different but are in the same compound. As shown in the records case map, the door of Faizul house faces west while that of my house faces south. If one comes from Faizul house, he reaches my house first and then Mansoor house. In my statement before the police, I did not mention on what type of motorcycle Azizul had come and what his registration number was, as it was dark. Since I could not read the number of Azizul's motorcycle, I did not mention about it. It is true that in course of my statement before police, I did not state about the fact that on the day of the incident, I had asked Azizul as to where he was going. There had friendship between Azizul and Faizul and there had no dispute between them. I do not know out of what grudge Azizul and others killed Faizul. The dead body of Faizul was found some 2-3 kilometers away from our house. It is true that I did not state to police that my mother and Faizul's wife were at home on the day of the incident. While giving statement before the police, I did not mention as to where I had seen Azizul and Faizul on a motorcycle. Around 6:37, I could learn over phone that from many people that Faizul had been killed. Since I practice cookery, many people know my phone number. They rang me up. On receipt of the phone call, I immediately went to the house of Mansoor and informed him of it. The place of occurrence is about 7-8 kilometers away from the place where we came across the police while they were carrying the dead body of Faizul. The name of that place is Amtola. Mansoor reached Nagabandha before me. Both of us before us together came across the police at Amtola. When police showed us the dead body of Faizul by taking it down from the vehicle at Amtola, I did not tell them about the fact as to who has taken him along and who had killed him. When the Ezahar was lodged with the police station, I was not present there. Before lodging the Ezahar, we had a discussion at home and asked many people to that effect. We named the accused person in the Ezahar on suspicion only since we did not witness the incident. Police took my signature statement in my house itself one day after the incident. Dacoit might have killed Faizul since the latter had 35,000 and a mobile handset with him, and we lost the case against Azizul and some others out of our suspicion only. PW3, Muklesur Rahman. I do not know the informant, nor did I know the deceased. Among the accused person, I know Dil Islam, who is present in the dock and is clad in a red t-shirt. I do not know the race accused person. It has been about 7-8 months since the incident took place. I am the VDP secretary of Nagabandha village. On the day of incident, some 6-7 months ago, while I was at home, I heard that a dead body was lying by the side of the road at a distance of 1.5 furlong from my house. Being the VDP secretary, I informed the police of the matter. Going to the place of occurrence, I saw the dead body lying there with a slit on its neck. Inquest on the dead body was held after the arrival of police there, and I put my signature therein as a witness. The deceased was known to me. Exhibit 2 is the inquest report. Cross. It was me who informed the police. First, I saw a lot of people near the dead body. More than 50 people were there. The identification of the fact as to whether the deceased was a Hindu or Muslim was done at the time of lifting the dead body on the vehicle by wrapping it with a bamboo mat. Theft and dokaiti are often committed at the place where the dead body was found. The incident of dokaiti robbing the people on the way are very common in that place. It is seen that exhibit 2 which bears my signature. If it, I was the PDP secretary. I know the 2 accused person to be the hotel employee. I do not know their name, nor do I know where they reside. PW4 is Uma Hani Begum. She is the wife of the deceased lodging. Among the accused person of this case, I know Azizul only. Deceased Faizul Islam was my husband. The informant is my husband's elder brother. It has been 8 months since the incident took place. On the day of the incident, my husband and I were at home. Around 7-8 o'clock in the day of the incident, Azizul came to our courtyard riding a bike. My husband Faizul asked me to give him his driving license, whereupon I gave him the same. He would purchase a new bike. Then Azizul took my husband Faizul Islam along on the bike he had brought along. As my husband did not return home till 11 p.m., I rang him up, but I got a busy signal from his mobile phone. At 11:45 p.m., I again rang him up, but found his mobile phone switched off. The next morning, my husband's elder brother Mansur Ali informed me that my husband was lying on the ground behind Singai College at Telia Bebezia. After giving me that information, my husband's elder brother Mansur Ali went to the place where the dead body was lying. I was at home itself. My husband's elder brother Mansur Ali told that my husband had been killed by hacking in his neck. After getting the postmortem examination done on the dead body, when police brought it to our house the following day, I saw it. I saw stitch on his neck. I did not notice the raised portion of the dead body. I saw Azizul taking my husband along with him. My husband's elder brother told me that some other persons were along with Azizul. My husband's elder brother Mansur lost the case. Police examined me. Cross. When I found the mobile phone of my husband switched off at 11:15 p.m. on the day of the incident, I thought that my husband might have been in his shop and that charge of the battery of his mobile phone might have got drained off. Since my husband used to stay at the shop occasionally, I did not worry about him at all. My husband used to stay in his shop occasionally if there had any problem. I have known Azizul since before, as he was the friend of my husband and he used to visit our house on earlier occasions too. My husband had a good rapport with him. I am not aware if my husband had any enmity with him. It is not a fact that I did not state to police that Azizul was at home on the day of the incident. That Faizul, before leaving home along with Azizul, asked me for driving license, saying that he would purchase a new bike, and that after I had given him the driving license, he went away along with Azizul. It is not a fact that I did not state that at about 11 p.m. on the day of the incident, I had rung him up before, but I had got a busy signal from his mobile phone. That when I had ring him up at 11:45 p.m., I found his mobile phone switched off. The next morning, my husband's elder brother Mansur Ali had informed me that my husband was lying dead with his neck slit behind Singai College. Prior to this incident, Azizul used to visit our house riding a motorcycle, and my husband also used to go out of the house along with him sometime. I am not aware if my husband used to gamble with others at night. On the day of the incident, my husband had rupees 30 to 35,000 with him, and he also took a bank form along to purchase a bike. He did not tell me as to where from he would purchase the bike. Prior to the incident, my husband used to return home at 10:30 p.m. After closing his shop besides me, my husband's elder brother was also at home, and he also saw Faizul going along with Azizul. I did not tell the police what dress Azizul was clad in. Police did not seize torch or any other material. PW5 is one Alaluddin. He was declared hostile lordship. I know accused Dil Islam and Azizul Islam, Azizul, who are present in the dock. I do not
What
know
happened
the
in page 23? What is this? Page 23?
is cross. In the middle of cross-examination of the witness, learned counsel for accused Abdul Salam declined to cross-examine his witness and left the court premises. Hence, the evidence of this witness is closed.
What is this? All right.
PW5. I know accused Dil Islam and Azizul Islam, who are present in the dock. I do not know the another accused. Informant Mansur Ali hailed from Pokotgaon. I knew this is Faizul Islam. The incident took place about 1.5 years ago, around 9:30 p.m. on the night of the incident. While I was watching TV by sitting in a shop at Amtola Center, I saw 3 persons going towards Juria on a motorcycle. The following morning, I could learn that after the murder of Faizul Islam, his dead body had been left on the road near Juria police station. The house of Faizul Islam is 1 furlong away from that of ours. I went to the place of occurrence and saw blood there. Police examined the dead body of Faizul Islam. A lot of people gathered there. Police took my statement. It is not a fact that I saw the accused persons going on a motorcycle. At this stage, PW there is hostile. Cross. It is not a fact that I did not state police around 9 p.m. on 1/5/14, I was watching April Fool movie under a tree in front of Ali Islam shop. I was sitting there as one person was supposed to give me money. About that time, 3 persons went there on a bike. Dil Islam was riding the bike while Faizul Islam was sitting in the middle and Azizul Islam in the back as pillion rider. Cross for Dil Islam and Azizul. Neither the accused nor the complainant is related to me. It was dark when the motorcycle reached there. Seeing the headlight, I could know that it was a motorcycle. Motorcycle fly even after the dusk. Motorcycle fly till 10:11 p.m. The said road is Nogak Juria main road. One can drive vehicle or motorcycle on the Pakka road at the speed of 60-70 km per hour. I saw 3 persons going on the motorcycle. There were 3 persons on the motorcycle. I do not know the registration number of the motorcycle. In my statement before police, I did not state that Dil Islam had been driving the bike while Azizul Islam was sitting in the middle as pillion rider. PW 6. I do not know the accused person who are present. Complainant Mansur Ali is my brother-in-law. Faizul is my DOI, that is the brother-in-law of my elder sister. The incident took place at night about a year ago. On the day of the incident, I was working in my tailoring shop at Silongoni, Amtola till 9:30 p.m. On the day of incident, Faizul along with 2 other persons came to my shop on a motorcycle and informing me that he would return soon. He immediately went with the 2 persons towards Juria. The following morning, I heard that Faizul had died. I saw his dead body when it was brought to Amtola. I do not know how Faizul died. Cross. My shop is 30 feet away from the road. There was no light on the road. I could not recognize the 2 companions of Faizul. Then the shop near that of mine were closed. No other person was present there. Faizul's elder brother is my own brother-in-law. Some 8 to 10 days after, police squeezed me in connection with the incident. Except for police, I did not tell anybody that Faizul had met me around 9:30 p.m. on the day of the incident. It is not a fact that I have adduced false evidence since the deceased and the complainants are my relative. Juria Road is a main road and it is a Pakka one. PW 7-1 Khairul Islam. I know the accused person present in the dock and do not know the another one. To quote, the PW pointed at the accused person. When the PW is asked to say their name, he says that they are Nazrul Islam and Azizul Islam. Again in C for witness. This is Faizul Islam was my maternal uncle. Around 9 p.m. on 1/5/14, the accused duo went to my shop along with my maternal uncle and purchased cucumber and tomato from my shop. My maternal uncle told me that they were taking him along to show him a bike. My maternal uncle Faizul Islam went along with the accused. The following morning, I came to know that maternal uncle had been killed. I do not know where the accused duo and my maternal uncle had gone. Later, police interrogated me. Cross. After the incident, I have seen the accused duo in the court today. I do not remember the date on which date police took my statement. Prior to the incident, I saw the accused duo moving around with my maternal uncle. I often saw the accused duo in my maternal uncle's shop itself. I did not know their name. I did not tell the police which villages the accused duo belongs to. My maternal uncle Faizul house is about 2.5 kilometers away from my shop. A market is also there in Pokotgaon, a short distance away from the market. When the accused duo and my maternal uncle went there, no other person was present there. Then I was about to close my shop. It is not a fact that in the night of the incident, the accused duo and my maternal uncle did not go to my shop. It is not a fact that I have adduced false evidence since this is Faizul was my maternal uncle. I read up to class 9. Prosper Nazrul Islam. I stated to police that I knew the accused person, but I do not know whether police recorded that or not. Police did not call me to identify the accused person. The shop of Talibur Rahman, Ismail and Alaluddin are there near my shop. Police came to my house to record my statement after 4 days of the incident. I came to know in the morning that my maternal uncle had been killed. My maternal uncle dead body was lying by the side of Juria Road. I went to see the dead body. The place of occurrence is about 4 or 5 kilometers away from my shop. Accused Nazrul is a driver and other two accused persons are salesmen of hotel by occupation. It is not a fact that Nazrul was driving a truck on the day of the incident. I told the family members that the accused duo had come along with my maternal uncle. It is not a fact that the accused duo did not go to my shop with my maternal uncle Faizul in the night of the occurrence. Accused Dil Islam and Azizul work in a hotel at Thing, which is 2 kilometers away from my shop. I do not know whether they work in the hotel by staying at the hotel. It is not a fact that the accused Dil Islam and Azizul Islam were working in the hotel on the day of the incident. PW8 Ali Islam. I know accused Azizul Islam and Dil Islam who are present in the dock and do not know the another accused. Around 9:30 p.m. I went to purchase goods for my shop. While I was carrying the goods, Faizul, accused Azizul and another boy were going toward Juria on a motorcycle. Since they were going slowly, I could see Faizul and asked him where he was going. Whereupon Faizul replied that he was going toward Juria. The following morning, I could learn that Faizul had been killed. Police took my statement for Azizul and Dil. This is Faizul was my brother-in-law. Khairul Islam is the nephew of Faizul. My shop at Bhakatganj Sariali, but my house is at some distance. I have a hotel cum pan shop. I went to bring goods riding a bicycle. I went to fetch goods at wholesale prices from Ali Islam at night. Except the shop of Ali Islam, others are small. I did not notice any shopping bag in the hand of Faizul when they went past me. Here the handwriting is in a police took my statement 1 week after the incident. I did not discuss with anybody regarding the incident. Amtola, my house. It is not a fact that I have reduced false evidence since Faizul is my brother-in-law. It is not a fact that no shop remained open till 9:30 p.m. Cross for Nazrul. It is not a fact that I did not state to police that I had gone to fetch goods at night. I did not go to Juria to see the dead body. I did not witness how the incident had occurred. It is not a fact that in course of my statement before police, I did not state that person who was driving the car was wearing a helmet. It is not a fact that I did not state that the bike was being driven slowly since the road was not in a good condition and that I could recognize Faizul and Azizul. That was the main road. People use the road. Other vehicles also pile on the road. It is not a fact that I did not go to fetch goods that day. It is not a fact that I have deposed falsely. PW9 is the mother of the deceased lordship. I know accused and accused persons by their name and faces. The incident took place about 1 year ago. Faizul Islam was my elder son. On the day of the incident, accused Azizul informed over phone that he had brought goods to his shop and asked Faizul whether he would purchase the same. Around 7 p.m., accused Azizul came to our house and took my son Faizul along on his motorcycle. The following morning, I came to know that Faizul had been murdered. Azizul took Faizul along with him on the pretext of giving him the goods of his shop. Police recorded my statement. Cross. I have known accused Azizul Islam by his name and face since before. He is a companion of my son. There had no dispute between them. I do not remember who else were at our house when Faizul was taken away. Accused Azizul came to our house and took Faizul along with him. I was inside the house itself. I do not remember whether the night was a moonlight one or a dark one. Amtola Bazaar is 1 kilometer away from my house. There are shops at Amtola Bazaar. It is not a fact that accused Azizul did not take my son away on his motorcycle from my house. So, cross for Nazrul is declined, Lordship. Then the medical evidence, Lordship.
So what is there? Only these two persons were seen
Yes.
by two of the witnesses, family members.
More than 2 witnesses. Till 9:30, they saw, witnesses saw them. Because he was sitting in between and your lordship, then thereafter there was leading to discovery from Nazrul, that's how he was roped in, my lord. And there's no explanation from the side of the accused at what time they have left the deceased. There should have been explanation. And plea of alibi has been taken by them, which was lordship, 2 DWs were there. But your lordship in 313, they don't say. On that very day, they were there. Although DW 1 and 2 said he was there, they were there. But in their own statement under 313, they don't say that.
There is a judgment of this court
Yes,
on last seen together circumstances,
yes.
which was delivered after referring to some decisions of the Supreme Court. Do you have the judgment? Is it there? I think something was held there, whether, Ms. Sharma, do you have the judgment?
The High Court judgment is not lordship, but I have gone through
And your
some of the.
lordship, medical evidence, it's within 24 hours. So it relates to the time.
That is correct. You
Yes.
see, the what are the proven facts? Let's
Yes.
take it.
Yes,
Let's take a case for a moment in favor of the prosecution, because there is a judgment of conviction. Three things have been established by prosecution. Number one, that the deceased died of homicidal death.
Homicidal.
Then his dead body was found on the road, which is away from the house, on the next morning.
Yes.
And in the previous evening, around 9:30, these two persons came in a bike and took him away with them. These are
One was
the-
acquitted, out of that, one was acquitted,
One
one
was-
not.
that's what we're saying.
Yes,
So this is the sum total of evidence. Apart from that, other things are not known or established, correct?
yes,
Now, the evidence which is available is the same for both the accused persons. There were three accused
three
persons.
accused, one was acquitted, two convicted.
So the two persons who were seen in the motorcycle, they are the appellants here, right? They are
No,
then-
No. Dil
Another
Islam-
person
Dil Islam was acquitted.
who went to another independent witness
Hmm.
to give the motorcycle.
Hmm.
He said that for the night, you give the motorcycle because it's not in working condition. That is the Nazrul Islam who has been convicted.
Nazrul Islam was
And
not
there was-
seen by
Yes.
any of the. any of
Yes,
the
only
witness.
Dil and other person.
Dil was
Ajizul.
acquitted.
So how can this conviction be sustained then? I think that judgment very elaborately deals with last seen
LR
together.
Majumdar sir, no?
None
LR
of you
Majumdar
have the
sir.
judgment.
The High Court judgment is not there, but in the main
Last time-
principle, what I found is that the last scene is of the such extent that there is no possibility of any third person, that during that period that there should not have been any such.
No,
That
no,
is
there is a
the-
recent judgment of authored by Honorable Justice Surya Kant. Where is the judgment? That judgment was taken note of in this subsequent decision.
Your lordship. Mr.
That is the judgment. That is reported perhaps.
LR Majumdar is part. Oh. No, actually. Abdul Kadir no, actually. Abdul Kadir also lordship, your lordship discussed about contradiction, how it should be proved.
Correct, but is that the judgment where there was one aspect was last seen together circumstance?
Abdul Kadir.
Lordship has.
It is Supreme Court too.
That is based on some Supreme Court judgment, recent judgment.
Last seen, lordship, Abdul Kadir is about 1 year back, if I'm not wrong. No?
You have not read the judgment. You have also not.
Recent one, my no? Abdul Kadir I have read already. I was only there.
Any idea whether any appeal has been preferred against this?
Oh, sure. No,
All right, so what is the submission?
Lordship, here Lordship, in the Azahar, one person was named, he was acquitted Lordship. Although there is evidence, if I will go by the evidence Lordship, the Azizul and Dil Islam, some are said Lordship. Most of the witnesses are the family members, and there is no motive Lordship, and in their statement also, they are not corroborating that who actually are. Some in some places they are saying that Azizul is there, somewhere they are saying that they could not recognize because of the dark, etc. PW7 is one witness who had identified them that his evidence is that both the deceased went to his shop to buy some tomato and cucumber. But in Lordship, his 161 statement, which was recorded Lordship, he had not named any person in that statement. In there, his 161. More so, Lordship, that Nazrul Islam part is that one bike, PW 11 and 12 stated that he had left one bike, but the arrest memo of the PW, this accused is of 5 p.m. And Lordship, according to these two witnesses, he went to at the time when they are taking their night dinner. So if he went there, when they are taking their night dinner time, Lordship, how he was already arrested by arrest.
There can't be a morning dinner. Dinner has to be.
Yes, Lordship. So definitely, Lordship, if he was arrested by evening, how could he left the bike at night, Lordship, on the same day? So, and that is the bike that is used, those things were also not there.
That is not there.
Not there.
Yes. The color of the bike, registration number, and the location could have, the police could have investigated into the matter.
Mobile phone.
CDR, because wife on the previous night, when Lordship, the husband didn't come on time, she gave him a call at around 11 o'clock. Then that time his mobile was busy, and then thereafter it went on switch off mode. But no CDR, nothing.
And the possibility of docaity is not
Is
ruled
also
out.
there.
They had also admitted that. And that Azizul had totally
Looks
denied.
like it should be a case of benefit of doubt.
Lordship, but there should have been an explanation on what time,
That
because
you're
they were
right.
seen
Explanation there should have been, but explanation is only an additional. link.
additional link. My last scene also an additional link.
So let
but-
us leave aside the explanation.
Yes.
Minus that,
In
What
fact,
is-
their statement is that Azizul, that he never taken him. So if he had not taken him, to when they are separated, that point is not material, Lordship. And this plea of alibi supposed that at the case of the accused, that they were all along in their respective shop, Lordship. So seeing
Accused
them,
person, according to DW 1 and 2, they walked in the hotel.
and they
At the on the very day they were there,
They
but
were there.
accused person did not take that plea. DW 1s have and 2 have taken that plea.
No,
But they
Lordship,
didn't, themselves had not taken that plea. Neither.
DW,
One and
this
two
accused
equals,
313,
No, so last-
330,
yes.
yes, Lordship.
They didn't
Page number
say.
34.
On the very
I
day
know
they
nothing
were-
about the date of Faizul. I could learn about the incident only when police arrested me. I am innocent. I did not kill Faizul, because this is what what
no.
they have
He
asked
wanted
him.
last those-
this- This is by Azizul, because Nazrul and other person was not asked that question. And plea of alibi, the DW1 had supported the case of the defense that they were in their respective shop till 11:30. And the Azahar was written on suspicion, and that too after discussing the matter, Lordship. So if they have suspicion
so what do
also,
you have to say? The accused have not given any explanation.
Lordship, Azizul, that question was asked to Azizul only, because Nazrul, Nazrul and other person, those question was not asked. Azizul had denied the charges, denied that he had ever taken him. And in his statement is that he came to know about the death only in the morning. He was never.
Case 54, sir. I work in Haji Hotel along with Dil Islam. Haji Hotel.
Page 54.
Case 54, they said they work, but on that very day, they were there in the hotel. That is not there, your lordship.
I work in Haji Hotel along with Dil Islam. I had known Faizul since before, as Faizul had a pawn shop in front of the hotel in which we work. I know nothing about the death of Faizul. I could learn about the incident only when police arrested me. I am innocent. I did not kill Faizul.
And other accused at page 58, I drive a vehicle. I am innocent. That is there.
Acha, you are available tomorrow. Tomorrow you are available. We'd like to close the matter tomorrow. You just have a very minute look.
Yes.
And if possible, go through the judgment also.
Yes, Abdul Kadir, I'll go through. And any.
Tell us whether the conviction can be sustained with this evidence.
Some of the factors goes against the prosecution that they discuss with the matter, discuss with some persons, family members as well as others, and thereafter they lost their fire. Lordship, regarding the vehicle, no detail is there. These two parts on lasting theory is there. But in between, Lordship, that proximity, but the postmortem says, your Lordship, it was within 24 hours.
No, but the problem is only on last seen together theory
Yes,
or circumstance.
yes,
When the prosecution case, there are some contradiction,
yes,
difficult.
yes.
Both of you
True, your
could
lordship,
look up
true,
some judgment
true.
on this.
There should be, time gap should be less, my lord.
Less means normally the Supreme Court judgments refer to about 1 or 2 hours, something like that.
Yes.
Even
I have got two
10,
judgments. I'll
12
refer
hours.
tomorrow.
Possibility of any other person should not be
Coming.
there if plus seen
And
together
they
has
have
to be applied.
taken the plea regarding committing of dockery in that area, that is there. But your lordship, yes, at the same time that the victim was also having 35,000 rupees. But he said that he will go with the accused persons to purchase the vehicle, motorbike.
So that's it. So only thing is that there is no plausible explanation. That's the only thing. Can that be the sole ground of conviction?
No, no possible explanation. Plea of alibi has been taken wrongly, my lord. They have not taken all the DW1 and 2 proved. And your lordship, medical evidence.
Plea of alibi has to be taken in 313.
No, may
Then?
not be. But they say they were there, they work in the hotel, but they don't say that on very day, they were there in the hotel.
And
That
there
is
is
not there.
no escape from there. They were working as regularly they work. That after the incident also they were there. There is nothing from their side that something unnatural. There's
And
those
your
things are
lordship,
not
the
there.
evidences of independent witnesses are also there. It's not that only family members have deposed there. Independent witness, your lordship, they said that they saw at around 9:30, they were there. They are not related. I think two
Two,
witnesses are
one is
there.
declared hostile and others no name is there. 2, 3 persons. That much is there.
If possible, just can you give a one-page
Lordship.